places. And so I was like, I saw it, it's coming up. And I was like,
Made from scratch in-house.
I know, that's what I was like, that makes me think that maybe I need to try it.
At least try.
Yeah. Hey,
Okay, so we are
So it's hash. on
almost
Sunday,
there,
and
almost there.
Dinner is the Friday before.
for,
So if Patty's Day is the
Patty's Day.
17th, so that'd
Right.
be traditional.
For
Cabbage and
cabbage and-
spuds,
Mhm.
Okay,
probably carrots if I was gonna be guessing that.
thank you for your patience with everything as we navigate additional
You know what I'm saying? Like,
challenges with technology.
Start the meeting at 6:03.
Okay. So
That was this is your cue.
right. So we're going to be going through a Public Records Act training. Actually, sorry, I need to write. Get something right off.
we have to go through this every once a year.
There's training that you need to go through. I think it's every 4.
Open Public Meetings Act and Public Records Act are every 4 years by, and they'll tell you, by state law.
Mhm.
So if we do this every so often, it
So
would
this
cover,
qualifies as the training.
this qualifies as the training, yes. So, I will share my screen. And I will share the sound, although I don't know how this training will go. It's a little bit different than the others. Each training seems to be different. So again, this is kind of like an e-learning as you go through. And so I will read the script. And it just says that this is a public records training for city and town council members and mayors. The slides will automatically advance. I can play, pause, rewind as we need to. And the volume is up. And so
Council members and mayors.
Oh, there we
Here
go.
are a few tips about navigating this training. The slides advance automatically. If you would like to read the script during the training, click on the Script tab at the top. You can use the Rewind button to restart a slide. Play and pause buttons are available at the bottom of the screen, and the next and previous buttons are at the bottom right and can be used to navigate between slides. The information in this e-learning is intended as general information for educational purposes only and does not constitute legal advice. The information is up to date and correct as of March 2021. Through this e-learning, you are able to link to other resources and websites which are not under the control of AWC or MRSC. Neither AWC nor MRSC controls the nature, content, or availability of those sites. Hello, I'll be guiding you through today's training session on public records. This e-learning experience is being brought to you by the Association of Washington Cities, also known as AWC, and the Municipal Research and Services Center of Washington, also known as MRSC. This training session is customized for city and town council members and mayors. Today's training is particularly important because it will allow you to fulfill a state law training requirement for public records and record retention in accordance with the Open Government Trainings Act. A separate training is required to meet state law training requirements for the Open Public Meetings Act. AWC and MRSC have a similar e-learning training for open public meetings, which can be found on AWC's e-learning by category page, which is linked in the Resources tab above. The goal of this training session on public records is to provide you with need-to-know information as required by the Open Government Trainings Act, and do so in a manner that's interactive and interesting so that you'll remember what you learned today. For today's training, I'm inviting you to follow along with a new council member. Welcome!
Thank you. I'm looking forward to this training and I have a lot of questions about public records.
You've come to the right place. I'll be answering your questions
yeah.
and providing practical information based on the experience of others who have faced these same issues. There's much to cover, so let's get to it.
Before we begin, could you tell me about the Open Government Training Act?
The Public Records Act, which I'll refer to as the PRA, and the Open Public Meetings Act are included in the Open Government Trainings Act. For the purpose of today's training, the Training Act requires city and town council members and mayors to complete training regarding the PRA and records retention law. For those the law applies to, they must receive the required training within 90 days of assuming office or entering into their position. Refresher training is required in 4-year intervals thereafter. Today's program is designed specifically to allow you to meet this requirement.
As a council member, do I really need training about the details of the PRA and records retention law?
Yes, you do. You took an oath of office to uphold the law, including the laws on public records and records retention. Also, as a council member, you have the authority to establish effective policies for your city or town to implement these laws. Today's training will provide you with information you need to know about these laws so that you can establish such policies.
Okay, so what topics are we going to cover today?
As you can see from this listing of topics, we'll be covering a lot of ground today. Take a moment to scan down the list. I'll talk about all of these topics to ensure we're in compliance with the Open Government Trainings Act. I'll also offer several recommendations based on what's working for other local governments throughout the state.
I'm particularly interested in penalties. Are the penalties under records retention law and the PRA serious? Can council members or mayors be subject to penalties against them personally?
Yes, the penalties are serious and can have significant impacts on you and your local government. Under the records retention law, a person can be found guilty of a felony for willfully and unlawfully destroying public records. Under the PRA, although individuals aren't subject to personal liability, the local governments can be subject to penalties, costs, and fees.
What kind of penalties, costs, and fees?
The penalties under the PRA include both statutory penalties as well as costs and fees. If a PRA requester wins in court, an agency will be subject to daily penalties ranging from $0 to $100 for each day the requester was denied the right to inspect or copy the public records at issue. The trial court decides the amount, and the court will award attorney fees and costs to the requester. In determining the daily penalty, the court will consider several factors, including proper training and supervision of the agency's personnel. Now that you have some background, let's move into other public records topics that you need to know. To avoid possible unintended consequences, it's important to think before you act. Consider, are you creating or using a public record? Will it have retention value? How will it be retained? How will it be made available if a PRA request is made?
I'm on board with this training, but are you sure that council members and mayors need to know anything more than very general information about records retention law?
Based on the experience of cities, towns, and other local governments throughout the state, the answer is yes. It's important that you, as a council member, know about the records retention law, not only because it applies directly to you, but also because the records retention requirements impact your city or town and its personnel, especially those who are managing the agency's records on a daily basis. Council members and mayors need to have a working knowledge of the records retention law so they can enact and implement appropriate policies for your agency and effectively allocate resources.
I got it. So what are the general purposes of the records retention law?
Those purposes include classifying various types of public records, describing who's responsible for those records, providing records retention schedules that specify retention requirements, and establishing requirements related to the destruction of public records. Also, keep in mind a point that's overlooked by some. It's generally easier to search for and find records responsive to PRA requests if the agency hasn't retained a bunch of records that don't have retention value. Regarding records retention, it's the content and function of public records that determine how long an agency is required to retain them. Under the Records Retention Law, a public record is a record that is made or received by an agency in connection with the transaction of public business, regardless of physical form or characteristics, and including such copies thereof. Consider the following framework regarding the Records Retention Law. A record is either not a public record with minimal retention value, or a public record with more lasting retention value. For the first category, records that aren't public records, generally this means a record that isn't connected to the transaction of public business. For such a record, no retention is required. A few examples of such records include an email to a friend or family member relating solely to personal matters and not to agency business, or a Facebook post to a personal page not relating to agency business. Regarding the second category, some records are public records, but they have limited retention value. Such records can be destroyed as soon as they are no longer needed for agency business. Some examples include secondary copies and transitory records. Secondary copies can include reference or convenience copies and CCs of letters or emails. Transitory records generally are records that only document information of short-term value and aren't needed as evidence of a business transaction and aren't covered by a specific record series. An example of a record that would be regarded as transitory is a community affairs notice, such as a notice that states, "Combined Fund Drive Luncheon is today." Other examples of transitory records include internet browsing history and to-do lists. Moving to the third category, records that have lasting retention value need to be retained by the agency for the specified minimum retention period. The vast majority of public records have retention value. There are retention schedules that cover all types of public records, including specific schedules for local governments. These schedules establish the minimum retention period for public records and can be found on the Washington State Secretary of State's website. I recommend that you work with your agency's public records officer to ensure that all of the agency's records are retained in accordance with the applicable records retention schedules. Now let's turn from records retention to the PRA. Our legislature has declared several general principles related to the PRA, including that the people of Washington State don't yield their sovereignty to the local governments and agencies that serve them, and they don't give their public servants the right to decide what is and what isn't good for the people to know. The PRA also provides that the people insist on remaining informed so that they may maintain control over the instruments they have created. Two other key principles are that the PRA is to be liberally construed and its exemptions narrowly construed to assure that the public interest will be fully protected. If there's a conflict between the provisions of the PRA and any other act, the PRA's provisions govern. Under the PRA, a public record is defined broadly to include any writing containing information relating to the conduct of government or the performance of any governmental or proprietary function that is prepared, owned, used, or retained by that government regardless of physical form or characteristics. Think POR, prepared, owned, used, or retained. Also, think about whether the content of the record relates to agency business. Public records can take many different forms. They can be paper originals and copies, emails, and other types of electronic documents, such as scanned copies, as well as audio and video recordings. In the social media context, blogs, Facebook pages, and Twitter feeds can be public records.
What about electronic records?
An electronic record, just like any record, is a public record if it contains information related to the conduct of government or the performance of any governmental or proprietary function, and it has been prepared, owned, used, or retained by the agency. Electronic records must be retained in electronic format. If a PRA requester requests a record in electronic format, the general rule is that it's to be provided in electronic format.
What about metadata?
Generally, metadata is data about data, or hidden information about electronic records that's automatically created by software programs. In the context of an email, for example, metadata can include the dates an email was sent, received, replied to, or forwarded, blind carbon copy information, and sender address book information. Metadata is subject to the PRA, but a requester must specifically request metadata for an agency to be required to produce it. A key concept to keep in mind in determining whether a record is a public record is to consider the content of the record. A record is a public record if it relates to the conduct of government or the performance of any governmental or proprietary function, and it meets one of the poor factors I described earlier. In contrast, a record is not a public record if its content relates solely to personal matters and not to agency business. This is true even if the record is located on city-owned computers or a city email account. Another key concept relates to the use of the record. Courts have held that a record is used by an agency if the record contains information that the agency either employs for, applies to, or makes instrumental to a governmental purpose.
Can you clarify what would not be considered a public record?
Yes, entirely personal records, even if located on city computers or city email accounts, are not public records. And certain personal notes, telephone messages, and daily appointment calendars aren't public records if they meet a four-part test. They were created solely for the individual's convenience or to refresh the writer's memory. They were maintained in a way indicating a private purpose. They weren't circulated or intended for distribution within agency channels, and they weren't under agency control. That said, it's important to follow this general principle. If in doubt about a record, regard it as a public record. Another important principle is that an agency is not required to create records in response to a PRA request. So, for example, if an agency properly deletes a record in accordance with the applicable retention schedule and later a PRA request is made for that record and no other records are responsive to that request, the appropriate response from the agency would be that there are no records responsive to the PRA request. However, once a PRA request is made and while it's pending, a record responsive to the request cannot be deleted, even if that record could have otherwise been destroyed based on the applicable retention schedule.
Now that you've sparked my interest, what's a good way for me to find out about the general obligations that my agency has under the PRA?
MRSC has several helpful guides on the PRA, including one entitled PRA Agency Obligations, a Starting Point, which can be accessed through MRSC's website. A link to this guide can be found in the Resources tab above. Agency obligations under the PRA include assigning a public records officer, publishing a list of exemptions and prohibitions that are found outside of the PRA, maintaining an index of public records, adopting a PRA fee schedule, providing for a review procedure for any denial of records, and complying with public records training requirements. Is this a public record? The following slides will give you 4 examples of common agency documents. Review each document and then select either yes or no to indicate whether or not you think the document is a public record. A council member is given a phone message to call their dad for his birthday. Is this a public record?
No. No.
You're supposed to hit the
I'm
button.
like, oh gosh, sorry. Like the entire time it just moves forward until now. Oh, sorry.
That's correct. Based on these facts, such a personal
Good
note
job,
would
Leon.
not be a public record because the content of the note is solely personal, meaning that the content doesn't relate at all to the conduct of government. Also, the manner in which the note was written indicates that it has a private purpose and that it wasn't intended for distribution within agency channels. The council member received this text message from a resident he knows from his city. The two had recently met at a coffee shop and had a discussion. The text was sent to the council member's personal cell number. Is this a public record?
Are we supposed to be able to see what that message is?
Oh, sorry. It says, it was a good meeting with you this week at the coffee shop and catching up about your interests as a council member. I don't envy your position at this week's council meeting. Do the right thing, vote yes on the plan to build a new city hall.
Oh, that'd be a yes. That's a yes.
That's correct. Even though the text message was sent to the council member's personal cell phone number, the content of the message clearly relates to the conduct of government. Also, the apparent purpose of the text is to persuade the council member to vote a certain way. The sender of the text is asking the council member to vote yes on a matter that will be coming before the council for a vote, and the sender is also referring to a meeting between the two related to city council business. As such, this message would be a public record.
So how do we retain that if it's on a personal phone?
Screenshot.
Yeah, so you can do it a couple of ways. You could do a screenshot and then email it to yourself. Or you can, so the tricky part is when it comes to metadata. It's like if you have the metadata and that's what's requested. But there's, and I don't know what the retention schedule is for something of that nature. But just don't delete your texts is the other thing. So what ends up happening, and so one of the things that we tend to encourage staff is to, have a separate phone for city business. So we had one for the building inspector, and then we don't anymore. I think people are more comfortable using their cell phones. The risk in that is if something like this is a record that is requested, then typically you give up your device for a period of time so that they can retrieve those records. Right. If they are requesting for the metadata. If you want to get a bit more sophisticated, one thing that you can do, again, I would only recommend it if it were for city cell phones, is you can have there's a service to where it downloads all of the text messages and all of the phone activity, and holds it for public records retention.
Okay.
So that it doesn't have to stay on the phone, it stays in a different repository.
Okay.
And also, going back a couple slides ago, we do have a policy for public records. I can put it on the side or email it out if you have any questions on that.
This is a page from a council member's personal calendar purchased with her own money. She keeps personal information in her calendar, and occasionally there's a reminder related to council meetings. Is this a public record?
No.
That's correct. This page from the council member's personal daily appointment calendar would not be a public record based on the purpose, use, and content of the document. The appointment calendar is the council member's personal calendar that she purchased with her own money. She uses it for her own personal use to keep track of personal scheduling commitments. The entries relate to matters that are solely personal, except for an occasional reference to a council meeting. In analyzing such situations, courts have also considered whether such a personal appointment book is solely for the individual's convenience or to refresh the writer's memory, whether it's maintained in a way indicating a private purpose, whether it is circulated or intended for distribution within agency channels, and whether it's under agency control. Here, these considerations indicate that this page from the appointment book is not a public record.
How does
The council member received this email from a neighbor who is a friend of his.
that apply to virtual calendars?
It
So-
would be the same, I would see, as far as like, if it's a calendar that is solely personal in nature and you have it, the council meeting needs listed on there.
Yeah, but I'm thinking, I mean, you send us the invites. We have Google calendars attached to our city council emails. So those would all be public records because they were,
It's your city council email and it's
Yeah.
for, the
And-
intention of that is for city council business. But if you forward that to yourself
Mhm.
so that you have it on a personal calendar that maybe gives you, that you use more often, that personal calendar wouldn't become
Okay,
the record.
okay.
The email relates to a discussion the two had at a recent neighborhood picnic. Is it a public record?
So it says, John, good to see you at the neighborhood picnic. We're fortunate to have such friendly neighbors. Go Hawks, another Super Bowl, counting on it. Looking forward to watching more games at your house. I enjoyed our chat about the workings of the city council and the city budget. I know that some think spending needs to be slashed, but I see major long-term problems with such an approach for our city. Don't buckle to the pressure at this week's meeting when you vote on the budget. See you around. Wow.
Yes.
That's correct. Although most of the email message relates to matters that are solely personal and not city related, the email is a public record because the last part of the message clearly relates to city business and is a request for the council member to vote at an upcoming meeting against cutting the city budget. Additionally, the email was sent to the council member's city email address, further indicating that the sender's purpose is to persuade the council member to vote a certain way at an upcoming meeting.
I thought we were just friends.
Now let's cover a few practical tips related to the PRA. In responding to a PRA request, the agency needs to make available for public inspection and/or copying all identifiable public records unless a specific exemption or prohibition applies. Note that a request for all agency records is not considered a valid request for identifiable public records, and the agency can deny it. But if the requester asks for all agency records regarding a particular topic or containing a particular keyword or name, that is a valid request. Second, an agency can also deny multiple automatically generated or bot requests received from the same requester in a 24-hour period if the agency establishes that responding to the multiple requests would cause excessive interference with other essential agency functions. Assuming that the request is a valid request, however, the agency must also provide a reasonable estimate of the time that will be required to respond to the PRA request. The requester must provide fair notice to the agency that they are seeking public records. The agency can adopt a policy explaining the procedure for submitting requests, and the policy can include that it is best for all PRA requests to be submitted through the agency's public records officer.
When the agency receives a PRA request, doesn't it have a few options related to how to respond?
Yes, perhaps a good way to remember this is 5x5. Because within 5 business days of receiving a PRA request, the agency must either Provide a copy of the record or allow the requester to review the record in person, or provide a link to the agency's website to the specific records requested, subject to an exception we'll come back to, or acknowledge receipt of the request and provide a reasonable estimate of the time required to respond to the request, or seek clarification from the requester, or deny the request. Please note that the exception I mentioned previously regarding option 2 is that if the requester indicates that he or she can't access the internet, then the city must provide hard copies or allow the requester to view the records using a city computer. Now let's turn to what the agency must do to search for records. PRA law requires agencies to conduct an adequate search to locate records responsive to a PRA request. Key questions for your agency in this regard are: is the search reasonably calculated to uncover all responsive records? And can the agency effectively show that an adequate search was conducted?
Are there some practical tips you can provide related to what's required for an adequate search?
Yes, MRSC has a helpful guide on this topic as well, entitled PRA: How to Perform an Adequate Search for Records, which can be accessed through MRSC's website and the Resources tab above. Key considerations related to conducting an adequate search include implementing an effective system for locating, collecting, and organizing responsive records, searching every place a record is reasonably likely to be located, and documenting searches so they can be appropriately defended if challenged.
Aren't there a number of exemptions under the PRA?
Yes, the general rule is that if a record or information in a record is exempt, the agency isn't required to make that record or such exempt information available for inspection or copying in response to a PRA request. Keep in mind, though, that exemptions are narrowly construed under the PRA. Also, exemptions are permissive rather than mandatory, meaning that the agency has the discretion to provide an exempt record or exempt information. A useful source that includes a listing of exemptions is Appendix C of MRSC's Public Records Act publication, which you can access through MRSC's website.
What's the difference between an exemption and a prohibition under the PRA?
Unlike exemptions, which are permissive, prohibitions are mandatory. If prohibition applies to a record or information in a record, the agency is legally prohibited from making that record or information publicly available. If a statutory provision refers to information or records as confidential or otherwise prohibits disclosure, an agency generally has no discretion to release the record or the confidential portion of it as applicable. For example, Social Security numbers and certain taxpayer information are generally prohibited from public disclosure. Now let's turn to a few common situations that demonstrate how records retention law and the PRA apply in practice. What's a common scenario that you'd like to know more about?
I've got one. Can a council member use his or her personal laptop or desktop computer to conduct city business?
Often, an agency will provide for remote access to the agency's network, in which case, accessing the agency network with a personal computer to conduct agency business is fine. By accessing the agency network, you are conducting your work within the agency system. But if remote access to the network cannot be provided on a personal computer, then it's best to use only agency-issued computers to conduct agency business. By doing so, you allow the agency to properly retain its public records and locate those records in response to a PRA request. Also, you eliminate the basis for a search of your personal computer in response to a PRA request.
So one thing I wanted to say about that is the emails that we use are based on Gmail. And so if you wanted to create documents, I would highly suggest using the Google Drive to create and store those documents, because that would act as a server, and it wouldn't necessarily, then that data is then not stored on your personal drive. It is stored then on that city server. So.
But what if I happen to use my personal email to conduct agency business, or I save agency-related work on my personal computer?
If you don't have the option of accessing your agency's system remotely, it's critical to ensure that agency and non-agency electronic records are easily distinguishable and not mixed together on your personal device. This can be done, for example, by keeping all of your agency-related electronic files in a separate electronic folder. But keep in mind, if you use a non-agency account and/or electronic device to conduct agency business, a PRA request may necessitate a search of that account and/or device depending on what records are requested. Here's another opportunity for you to test your knowledge about public records. Read through the scenario described on the following 2 slides and then determine if a public record was created. Councilmember Smith was elected a few months ago and has never held public office before. When he was running for the position, Citizen Jones and others supported him because he agreed with them that the town needs reform. Councilmember Smith and Citizen Jones conferred often via email in the months leading up to the election. Now that Councilmember Smith is in office, Citizen Jones has continued to send emails to Councilmember Smith at the same email address she has always used, which is Councilmember Smith's personal email address. Today's email asks Councilmember Smith to bring up a reform package for discussion at the next council meeting. The email includes specific talking points that Councilmember Smith brings up at the council meeting. Councilmember Smith received the email on his personal email account, and he viewed it on his personal laptop computer in his home office. Now a PRA request has been made for the email message from Citizen Jones. Councilmember Smith's position is that the email is not a public record because it was sent to him via his personal email address and he viewed it on his personal computer in his home. Is the email considered a public record?
Yes.
Yes.
That's correct. It doesn't matter here that Councilmember Smith received the email via his personal email address and viewed it on his personal computer in his home office. What matters under the PRA is that the record relates to the conduct of government and that it was prepared, owned, used, or retained by the agency. The email received by Councilmember Smith from Citizen Jones includes talking points that relate to a town reform package, so the email clearly relates to town business. Also, in the email, Citizen Jones asks Councilmember Smith to bring the talking points up for discussion at a council meeting, so the purpose also relates to town business. Councilmember Smith then, at the next council meeting, used the email by bringing up the reform package for discussion before the council, and he covered talking points that Citizen Jones asked him to raise in the email. Given these considerations, the email is a public record.
But don't I have privacy rights related to my personal computer and other electronic devices?
Yes, but those rights are conditional when public records are involved. To paraphrase the Washington State Supreme Court, the ability of public officials and employees to use non-agency cell phones and other electronic devices and to create and exchange public records via those devices, whether those records are emails, text messages, or anything else, is why the PRA must offer the public a way to obtain those records.
What do you recommend related to use of an agency email account as compared to using a personal email account to conduct agency business?
It's best to use only an agency-issued email account for agency business. Just like use of agency electronic devices, Use of an agency email allows your agency to properly retain its emails and locate them in response to a PRA request. This principle applies as well for other electronic communications related to agency business, such as texts, instant messages, and tweets.
But what if I receive an email on my personal email account that relates to city business?
If this occurs, forward that email to your city email account and advise the sender that you don't use your personal email address to conduct city business and to send any future city-related emails to your city email address.
But what if my city doesn't have city-issued email accounts?
If that's the case, the City Council should work with your city's mayor or city manager to establish an email system that allows the city to assign individual addresses to each official and staff member. If the city does not set up a city email system, you should create a separate email account that's used solely for city business, such as something like councilmemberjones@gmail.com. And it's important to keep in mind that if you use a non-city email address or account to conduct city business, you need to consult with your city's public records officer and with the city or town attorney to address issues such as determining how those records will be retained in compliance with records retention law and how the records will be located and made available in response to a PRA request.
Can you pause it for a second?
Can I send city-related text messages from a cell phone?
So what if you're CC'd on an email? And you know what I'm talking about.
I do. It all depends. So, for example, council is copied on a lot of emails that are related to the county.
Yeah.
Those don't have anything to do with city business and can all be deleted.
Okay, that's good.
So, other items, I mean, it's discretionary, but for the most part, I would save it, just throw it in a file. We're not running up on any sort of, data concerns with council members as far as email goes. So, that's not an issue.
Okay,
So.
well, you answered my question. Thank you.
I'll start this one over again, maybe.
Can I send city-related text messages from a cell phone or smartphone?
Yes, but keep in mind that texting creates unique challenges as discussed in further detail in the next slide. If you utilize texting or instant messaging to conduct city business, key considerations for you and your city relate to who has custody and control of the record and how to access and retain such records. It may be that the service provider, such as the phone company, will retain text messages only for a limited time, so the city will need to develop a system such as by using software to retain texts that have retention value. The Washington State Archives has prepared several advice sheets related to texting, which can be accessed via their Managing Text Messages webpage. I recommend that you review and act consistent with those advice sheets and that your city complies with those advice sheets as well. Based on guidance from court decisions in our state, it's important for cities to adopt effective policies to address use of personal cell phones and other electronic devices as that use relates to city business. For example, the city could have a policy that prohibits use of personal devices for city business unless the employee agrees to comply with the city's policies regarding such use. Another important consideration is how to access records that may not be within the city's control. The PRA requires agencies to conduct an adequate search for records that may be responsive to a PRA request. This could include texts that relate to city business resulting from use of a personal cell phone. In order to meet its burden of showing that it conducted an adequate search in such a situation, the city can have its officials and employees submit reasonably detailed, non-conclusory affidavits that attest to the nature and extent of their search. In using this procedure, city officials and employees can segregate personal records from public ones. The city can establish this procedure as a matter of policy. For example, a city could require employees to agree to search for and produce any public records and to document that search upon request. A city could also seek consent from its elected and appointed officials in that regard. To be effective, though, such a policy should include consequences for noncompliance, recognizing that disciplinary options for elected and appointed city officials are different than for employees.
Can you clarify what type of text messages that I send from my personal cell phone may be public records?
Yes, particular guidance is provided on this issue in the Nissen versus Pierce County decision. Based on that case, if, for example, you as a council member send or receive texts in your official capacity, including if you use incoming texts by reviewing and replying to them within the scope of your employment, and the texts relate to city business, you can presume that those texts are public records subject to disclosure. A text or other employee communication is within the scope of employment in this context when the job requires it, the city directs it, or it furthers the city's interests. In the Nissen case, the texts at issue were sent and received by an elected official, the county prosecuting attorney. The court did not make a distinction between an elected official and other types of employees in applying the scope of employment test in that context, so we can presume that the test is generally applicable regarding such communications. Also, the Washington Court of Appeals applied the scope of employment test in the West versus City of Puyallup to hold that a city council member's Facebook posts on their personal Facebook page can be public records if the posts relate to the conduct of government and are prepared within the public official's scope of employment or official capacity.
What are some public records considerations related to social media?
Facebook and Twitter, for example, can be effective tools to connect with the public. But if your agency is going to create social media accounts, public records considerations need to be thought through and addressed. Unless the agency is posting only secondary copies of agency records to, for example, the agency's Facebook page or Twitter feed, it's advisable to presume that all posts, comments, and tweets are public records and to consider how to manage posts and tweets, retain such records, and use software tools to capture those records. As a general recommendation, don't use your personal Facebook page, Twitter feed, or blog for agency business. It's advisable for agencies to have clear and enforceable policies regarding such activities. Also, if you're an incumbent elected official who is a candidate, don't mix your election activities with agency business. Here is one more opportunity for you to test your knowledge. Read the scenario on the next slide and continue on to select the best answer. A member of your city council received an email from a citizen related to alleged corruption at the city. The email was sent to the council member's personal email account. At the next council meeting, the council member indicated in his public comments that he had received an email from a citizen about alleged corruption at the city and that the allegations were baseless. The email hasn't been provided to the city and it's only accessible through the council member's personal email. A citizen submitted a PRA request to the city for the email. Is the email a public record? Choose your response from the options on the screen.
I'd say it's E.
That's correct. Even though the email was sensitive and it only went to one council member via that council member's personal email account, the topic of alleged corruption relates to the conduct of government, and it clearly became public record once the council member specifically referenced that email in a council meeting as a part of the council's discussion about alleged corruption.
Do you have any final recommendations to leave me with?
Yes, as this training has demonstrated, the PRA and records retention law are wide in scope, and it can be challenging to be familiar with all of the requirements of these laws. That's why it's important that council members and mayors dedicate themselves to being knowledgeable about the PRA and records retention law and to comply with the many requirements of these laws. It's also important to create a culture of compliance at your city or town. The council, mayor, and staff, especially the public records officer, should receive regular and effective training about the PRA and records retention law to keep up to date. Also, it's important for the council to review its agency's policies related to PRA, records retention, and records management procedures to ensure that those policies comply with current law. It's important as well for agency officials and staff to consult with your city or town attorney about these matters and to be proactive if you have questions about whether a particular activity is allowed under the PRA and/or records retention law. Ask before you act.
Do you have any final recommendations?
The council, mayor, and staff, especially the public records officer, should receive regular and effective training about the PRA and records retention law to keep up to date. Also, it's important for the council to review its agency's policies related to PRA, records retention, and records management procedures to ensure those policies comply with current law. The Attorney General's Office Local Government Consultation Program can provide training and more on PRA best practices. The Washington State Archives has a local government grant program to improve technology information services for public records retention, management, and disclosure and related training. Links to both of these resources can be found in the Resources tab.
What about resources that are available to my local government?
AWC is available to cities and towns to assist with training and many other services. MRSC is also available to cities and towns to answer your questions about the PRA, public records, more generally, and other issues related to local governments, as well as to provide sample policies and featured practices that are working for cities, towns, and other local governments. Click here to download your certificate of completion.
And I'll fill that out.
Interesting.
So one of the contracts that council signed it was last year was for Laserfish.
Mhm.
And so we have that Laserfish scanner over there. And what that's going to enable us to do is to scan all of the paper documents that we have. And it does something called OCR, which is yes. So basically it takes documents and then you can search words that are within that document as well. So it will improve our ability to search records and then respond to requests. We do have a pretty robust system right now, but it's still all paper.
And the idea is that those requests can then be self-served.
Mhm.
Right. And so we're also working on, so there'll be a public portal so that people can look at those requests or
Search
look at the
something and find it.
documents
Yeah,
online, right?
nice.
So, yeah.
Cool. I like it.
It's it'll slow and methodical, but work in progress. So, anything else?
When can you deny a request?
I mean, typically I don't deny, I just basically say that there's nothing responsive to your request, or if it's overly vague, if it's like, give me all the records in the city since its inception. Be like, that is overly broad and this request is denied. So those are kind of
Everything to wood with the word mayor.
yeah. So for the most part, it's typically, asking for clarification or asking for it to be narrowed in scope. Sometimes what I'll do too is I'll be like, so the request that you gave me has, 5,000 documents. So do you want to narrow it down or I'll get it to you by the end of the year? So it just depends on,
Do we have a high volume of public records requests?
variable.
Okay.
Mhm.
Well, there was a request that I was CC'd on from the county level. And the new public records request officer said, I forget what the exact verbiage was, but didn't fall into the type of information that could be requested within the act. And he said denied. Just plain no.
And so a lot of what we get to sometimes is just a request for information or clarification. And so it's not necessarily asking for a specific record, but my practice, as you've seen, is to respond when I can, because I feel like, again, transparency, open government, like that's the whole purpose. And so trying to, if they're asking questions because something's unclear, and so trying to provide that clarity.
But when we get residents saying, and I would like to have this information provided anytime in the future, somebody else, like my neighbor, does this thing. He said, well,
Yeah, you can't request records in the future. So it's,
Potentially one day.
so if that's what you want, then you should like submit a records request every month or every year, like how.
I guess part of my point on that though is that it sucks that yes, because the whole idea is to make sure that we are held accountable for what we're doing. So that the government that's been created by the voters has not been taken away from the voters.
Right.
Right.
It's not a tool to spy on your neighbor using this tool.
Right.
And convincing someone of the difference can be the challenge.
And still be politically correct.
These
Yeah.
people have friends that are leaning on their politicals. Like, I don't have people coming over me like, so when you go to the next meeting, make sure I'm like, people don't do
Well,
that to me a
and,
lot.
and that's why, whenever we do anything quasi judicial as well, it's like, have you had any ex parte communication? Because even if you go visit the site sometimes and run into someone and they tell you something about it, that could
That's communication,
influence,
sure.
yeah, that could influence your decision. And we don't have those often. But yeah.
Interesting.
Good training.
Thanks for attending. And so the next one, as it was mentioned on the agenda, will be our retreat. And we'll talk more about that at the council meeting. So,
Memorial Day.
yeah, right? Yeah. Yeah. See that, Christy? It's
I'm
not gonna be
still-
Wednesday.
I'm
We're
still
just calling
smiling
it
as well.
Memorial Day, just
Yeah.
as a reminder. So,
Hey, I did this training in Longview. It was a lot longer.
yes. Well, this is just the shortened version of the Public Records Act. Further down, we'll do, I think, the Open Public Meetings Act. So I'm trying to keep these to like
An
hour
hour.
chunks.
Yeah.
I appreciate that.
Okay,
Meeting adjourned.
thank you.
See you, Christy.